afternoon. May it please the court, my name is Jim Taylor. I represent the appellant, Keystone Airpark Authority. I wish to reserve 3 minutes for rebuttal, if I may.
Okay.
Let me first state, if I may, that the principal issue in this case concerns the lower court's award of attorney fees based upon non-acceptance of a proposal for settlement pursuant to Rule 1.442. In our initial brief, we also argued that the lower court erred in awarding non-taxable costs. Passrow has pointed out in their answer brief that we did not raise that issue in the court below, and therefore it has not been properly preserved for appeal to this court, and we are constrained to agree, and therefore, respectfully, we will abandon that issue for appeal and focus only on the attorney fees issue. In that regard, Your Honors, I would like to focus on the first of the arguments on the fees that we addressed in our initial brief. That is that the proposal for settlement impermissibly requires release of causes of action that have not accrued, that were not accrued as of the time of the service of the proposal for settlement, but that may accrue or mature in the future.
Well, can I ask you about that? And maybe I'm interrupting where you're going to go, but in paragraph 3 or number 3 of the proposed release that was attached to the offer, goes on like these releases always do, arising out of the incident, an incident isn't defined, or from, upon, or by reason of any matter, cause, or thing whatsoever from the beginning of the world to the day and date of these presents. So to the day and date of these presents, meaning here's the cutoff right here, therefore no future claims are being released.
Your Honor, that is correct. And if I may, the focus of our argument is on that very paragraph, paragraph 3, which sets forth the terms of the release. And we believe that it must be read as encompassing 2 separate releases. First, and the distinction between the two, or the place where the 2 different forms of release fall, is on either side of the use of the disjunctive or in that long sentence, such that before the disjunctive or, the release is of any claims that the Airpark Authority ever had, now has, or which it hereafter can, shall, or may have against the released parties, which of course includes Passero, for, upon, or by reason of any damage to the counterclaim plaintiff arising out of the incident, which, as Your Honor observed, is not a defined term. We have taken incident to refer to the project, which is defined on the first page to encompass the project that is the subject of the lawsuit. That's one distinct release. The language on the other side of the disjunctive or is, Judge Bilbrey, the language to which Your Honor referred, and that certainly, under the construction of the exact same language in other cases in Florida, including the Bowman case on which Passero principally relies, that language has been consistently construed as a general release, which, as a general release, is limited to causes of action that had accrued as of the date of the release. What precedes the disjunctive or is a separate release of claims that the Airpark can, shall, or hereafter may have arising out of the incident. That contains no language that, I submit, can reasonably be construed as being limited to causes of action then accrued. And when we look at Passero's answer brief, as I read it, Passero asserts that it is not so limited because, among other statements in the answer brief, starting on page 11 and carrying over to page 12 of the answer brief, Passero asserts the fact that the existing alleged construction defects may continue to cause damage in the future and therefore potentially render the Airpark liable for other claims in the future does not diminish the enforceability of the proposal for settlement that waives such claims.
Well, I mean, say I'm in a personal injury accident and I've got pain and suffering, and in the future that pain and suffering is probably going to continue. I propose a release that releases, for X number of dollars, releases everything related to that, now, past, present, future, related to that cause of action, meaning 10 years from now I can't come back and say, oh, my arm still hurts, I want more money. I mean, why is that problematic?
Because, Your Honor, the facts in this case are different from the facts posited by Your Honor, respectfully. This is not a case where the accident happened, the injuries were sustained, and over time they may have worsened, or other manifestations may have presented themselves. This is a case where, by reason of the construction defects themselves, as the lower court has now found, the damage is progressive and is worsening over time. The lower court found that it presents a foreseeable risk that at some uncertain time in the future, if these defects are not remediated, that the buildings, the hangar buildings, could collapse. The concern the Airpark has, and the concern we have with this first release provision in this paragraph 3, is that if that were to occur, and it's not merely an academic exercise, if that were to occur at some point in the future, there are 14 leased hangar units in these buildings, and if there were building collapse, there's the risk of injuries or damages that could give rise to third-party claims.
How do you ever settle a construction defect case then? Because there's always a possibility of future, potentially foreseeable damages, that the structure may collapse, people may get injured, there may need to be more repairs than are readily apparent. Are you saying you can never release a construction claim because there's a possibility of more damages accruing in the future?
No, Your Honor, I'm not saying that. What I am saying, what we are arguing, is that we were unable to find any case in Florida that has approved a release for use in a proposal for settlement, or as part of a proposal for settlement, which purported to require the offeree to release unaccrued claims that may accrue in the future. This one does that. And so what we do argue is that's not permissible under Florida case law and should not be permissible because it imposes, if not an impossible, an unreasonable burden on the offeree to attempt to evaluate, in the context of the proposal for settlement with which it has been presented, to evaluate what potential causes of action could accrue in the future. Who might be injured? Who might suffer damages? What might the extent of it be? Claims not accruing to the Airpark, but accruing to third parties over whom the Airpark has no control, but whom the Airpark may get sued by. And in turn, the Airpark may have legitimate third-party claims for indemnity or contribution back over against Passero. That is the concern.
Can I ask, how many hangars are there?
Pardon me, Your Honor?
How many hangars were built?
There are 14. There are 10 T-hangar units and 4 bulk hangar units.
Does the proposal for settlement cover all 14?
Yes, sir. The project as it's defined in the release covers the 10-unit T-hangar, 4-unit bulk hangar, and all of the associated asphaltic pavement.
And were there these cracks in all the hangars?
There's 2 hangars, 2 hangar buildings,
I'm sorry, okay.
and the cracks encompass all of the asphaltic pavement and both of the hangar slabs. Yes, Your Honor.
And what I'm getting at is it sounds to me like this was a release that covered everything and everything that was understood to have arisen there, which are these cracks and so forth. So I'm a little concerned, and Judge Bilbrey brought this up, about how you could ever release something if what you're saying, I mean, maybe give us an example. What kind of unaccrued claim, is it a crack in the foundation of one of the buildings or that comes up 10 years from now? Or I mean,
Your Honor, Honor, if the question is, what could such an unaccrued claim be?
Yeah.
It would be, in our view, the very possibility I just referenced, that if unremediated, and the Airpark doesn't have the funds with which to effect the remediation, we're going to have to obtain those funds through litigation.
Yeah, but wouldn't you have negotiated that at this point? Would have negotiated that and said, well, we don't know if this hangar is going to be stable long-term. As a part of this litigation, we want to ensure that we have adequate resources to do that. Why wouldn't you get that remediation through the litigation that's currently here and the settlement of it?
I may have misunderstood Your Honor's question, if so, I apologize.
You've got a bunch of problems with all the hangars. Why wouldn't you, in the litigation, seek the damages to remediate all the problems now, rather than say, well, we're going to let them accrue and the building collapse years from now, and then...
That's exactly what we've done through this lawsuit, Your Honor, is seek to obtain from the parties we believe were responsible the funds as money damages that will allow us to remediate the defects. The case in the lower court has gone forward against the contractor and the contractor's surety, and has resulted in the entry of a money damages judgment in which Judge Lester awarded as damages what he found was the amount necessary to effect a complete remediation. That judgment is now also on appeal to this court. At present, we have a judgment, but we cannot collect on it. And without being able to collect on a judgment in this lawsuit against one or more of the defendants, the Airpark simply doesn't have the funds with which to remediate. As Judge Lester found, the cost of remediation is $2.2 million, $2.1 million. The Airpark Authority doesn't have that money. But it also needs the rental income from the hangar units, and so there are tenants in those hangar units. Nothing suggests that there's a risk of collapse now, but as Judge Lester found, the situation being that it is progressive and will not stop, and that's why the remediation cost is as much as it is, creates a risk that at some point in the future, unknowable, that may be an outcome. I am into my rebuttal time, so unless one of your honors has another question for me at this time, I will yield to Mr. Brown.
Good afternoon. May it please the court. My name is Kurt Brown. I represent the Appalachia Passero Associates. Passero Associates' proposal for settlement in this case and the attached release, it specifies what the construction project was, the number of hangars, the associated taxiways. It specifies what the underlying claims were for construction defects. It also notes the Airpark's position that its damages are continuing and permanent damages. But what the release does is it requires the Airpark to release all of its claims related to that project, number one. Number two, it requires the Airpark to release any other claims that it may have against Passero from the beginning of the world through the date that the release would be signed. And that's the language that was mentioned earlier here today. That language was construed by this court back in 2006 in the Brewer case and held to be valid and enforceable. What our release doesn't do is it does not require the Airpark to release future claims that would accrue sometime in the future based on events that have not yet occurred. That's the position that the Airpark is taking. That is not what our release does.
Can I ask you a question? Your client, they're architects or project managers. What do they do on this project?
They were performing part-time inspection services.
Is that it? Just, that's all they did?
They also did design of the project, but the claims were based on the part-time inspection during the construction phase.
Okay, so the claim was your client was negligent in the part-time inspections?
Correct.
That's it?
That's it.
The paragraph 3 of the proposed release, arising out of the incident, is one of the two things that are released, or all claims till the end of the beginning of the world till current. The incident is not defined. Does that create an ambiguity in the release that we don't, I mean, we can kind of presuppose what you meant by the incident, but it doesn't, the incident means X. We don't have that. Does that cause us problems?
I don't think so, because I think when you read the entire release, you read the proposal for settlement, it all relates to the underlying dispute, the underlying action, the construction project, and the construction claims. But when read together with on the other side of the or, it's requiring a release of all claims that existed as of the date of the release, which would necessarily include all claims arising out of the project that had accrued. In the Airpark's reply brief, they offer the same hypothetical that was discussed a few minutes ago, and that is that there could be a potential collapse of a building, of one of these hangars in the future. And I think the fundamental error in their analysis is that they are equating a future collapse of the hangar with an accrual of a future cause of action. And they are two different things. In a claim against an engineer for the design, improvement, and construction of improvement to real property, the pertinent statute is 9511(3)(c), and that creates a 4-year statute of limitation, and that time starts ticking from the date that the owner or the Airpark knew or should have known about, in this case, it would be Passero's negligent part-time inspection services. That's where the claim arises from. The future potential collapse is a manifestation of perhaps negligent inspection services. That's not an independent cause of action. So this case that we're here today on could resolve one way or the other. The Airpark cannot sit back and not repair these hangars and then eventually allow them to fall down, and then a new cause of action springs up. Because the facts that cause of action would be based on and the facts that our original cause of action was based on are the same. And those are the allegedly negligent inspection services. So, and in getting back to the magic language of beginning, from the beginning of the world to the day of these presents, those facts, the critical facts for both the inspection services, those occurred 10 years before this release was offered to the Airpark.
I understand that council was here a couple of weeks ago for a hearing on the summary judgment, or for the argument on the summary judgment issue. Does that have any impact, or the potential disposition of that have any impact on our case here?
Obviously, if that is reversed, then I think then this proceeding perhaps is premature. The other issue that's raised by the Airpark is an argument that there's some ambiguity due to the definition of Passero in the release. And as the releases typically do, it's Passero, and the language is, it goes on and lists agents, employees, parties, successors, affiliates, corporations in privity with or otherwise legally responsible for their actions. Again, that language has also been addressed, not by this court, but by the 4th DCA in the Bauman case. And the 4th held that The inclusion of agents, employees, et cetera, is simply standard language in a general release that should be considered unambiguous and should not invalidate the proposal. Again, that is no reason to find any ambiguity here. Due to the Airpark's position on the cost item, I have extra time that I'm not going to utilize, so unless the panel has any further questions for me, I will yield. Thank you.
Judge Bilbrey, I concur with Mr. Brown that if there were a reversal of the appeal of the summary judgment, that would moot this appeal. On the question of accrual, Passero's comments all have to do with when the Airpark's cause of action against Passero accrued. I agree that cause of action has accrued, but that's not the question of accrual that I think makes the first part of the release language problematic, because the accrual with which our argument is concerned is when third parties, such as tenants, for example, when any claims they might have might accrue. And under Section 95.031(1), we know that accrual occurs when the last element constituting the cause of action occurs. For any such tenant who may suffer damage or injury, that would be when the damage or injury occurs. It hasn't occurred as of now, not as far as we know, but it could occur in the future. And if that occurred, then those third parties could quite conceivably sue the Airpark, perhaps sue Passero, and if they were to sue the Airpark, quite possibly, I would assert, would have a right of action back over against Passero on a contribution or indemnity theory.
But isn't that something, though, that the Airpark can consider in determining whether this is a reasonable settlement amount? $50,000, not enough. We're not going to take it because potentially in the future things could collapse, somebody could get hurt, and we could be on the hook for $2 million.
Your Honor, I hope this doesn't sound too trite, but nobody can predict what's going to happen in the future, and I think it imposes an unreasonable burden on an offeree to have to attempt to evaluate what could be a worst-case scenario based upon events that may or may not happen in the future. And I suggest that's why no Florida court has ever approved a release under Rule 1.442 if it has involved causes of action that might accrue in the future.
I know you're about to run out of time, but perhaps with leave I could ask one final question.
Go ahead, Judge.
Would the nature of the damages being sought in the case matter under the release? In other words, special, consequential, I mean, does that play a role at all in how we interpret the offer? Or how the offer is to be interpreted?
Your Honor, as Your Honor may be aware, obviously that's the critical issue in the summary judgment appeal, is whether the damages the Airpark sought constitute general or special or consequential damages. For purposes of evaluating what kinds of damage claims could accrue and be asserted in the future, I would suggest that a party in the Airpark's position would have to consider all forms of damages, particularly in a tort context where there's no opportunity for contractual limitation.
Thank you.
Thank you very much.
Well, thank you, Mr. Taylor. Thank you, Mr. Brown, for your argument. We are adjourned.
All rise.